Are you satisfied and happy with your attorney?
Yes.
Mr. Keene, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Mr. Starky, are you admitting here today that you in fact did batter or injure a law enforcement officer?
That's what I've heard.
And you didn't have consent to do so?
No.
And are you admitting here today that you in fact did throw or expel urine at a corrections deputy?
Yes.
And you didn't have consent to do so?
No, I did not.
All right. Do you have any questions for the court or for your attorney before I proceed?
I do not.
Okay. Mr. Keene, did you go over the facts alleged in the criminal complaint with Mr. Starky?
Yes, Your Honor. Went through all four of them, and more recently, 24 CF 91 and CF 109, along with, we reviewed them on the 4th as well.
All right. And did you go over what the state would have to prove, those elements as they apply to the facts?
Yes, Your Honor.
Or as the facts apply to the elements, actually? Did you also go over his constitutional rights and what it means by waiving his rights?
Yes, Your Honor.
And did you go over the strengths and the weaknesses of the cases with Mr. Starky?
Yes, Your Honor.
And do you believe he's entering his pleas freely and intelligently and voluntarily here today?
Yes, Your Honor.
And do you believe he's entering his pleas competently here today?
Yes, Your Honor.
Do you have any concerns about your client entering his pleas here today?
No, Your Honor.
All right. Mr. Starky, one last time, do you have any questions before we proceed and before I have you enter pleas today?
No, I do not. I do not have any questions.
Then as to count 1 in 24 CF 91, battery to a law enforcement officer, and H felony, how do you wish to plead?
Guilty.
As to count 1 in 24 CF 109, prisoner throwing or expelling bodily substances, and I felony, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 charges. The remaining charges in those cases and the other 2 open cases will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. The court will order a pre-sentence investigation report, long form. Agent does not need to appear, but should be readily available by telephone in case questions arise. The court is again revoking bond. We have set sentencing, and that will remain on the calendar as already previously set. Anything else we need to address here today, Mr. Schmidt?
No.
Mr. Keene?
No, Your Honor.
All right. Then he may be sent back to Polk County so he can face his revocation there and whatever's going to happen there. And then once we determine what's going to happen there, we'll figure out sentencing and how that'll come into play. All right? All right.
It was at this moment that he knew he fucked up.
We will go on the record in the matters 24 CF 91, 24 CF 109, State of Wisconsin versus Justin Starky. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Starky appearing in person in custody with counsel Glenn Keene. We're set today in this matter for the sentencing portion of these cases. Mr. Starky pled guilty on March 7th, 2025 to 2 counts, 2 felony counts, 1 battery or threat to a law enforcement officer, and 1 count of, I believe it was felony prisoner throwing or expelling bodily substances, and I felony. The court ordered a pre-sentence investigation report, The court has received and reviewed the report. And in my review, even though I don't have as much detailed information as the counsels, the attorneys, I did not find anything that jumped out to me as being a material error or a fact that needs to be corrected. Mr. Schmidt, did you receive a copy of the PSI?
I did.
Any material facts or corrections to state on the record?
Not a correction per se, but he did get revoked in his Polk case and they just haven't done the sentencing yet.
All right. And do you know if that matter is currently scheduled for sentencing?
It was scheduled for sentencing yesterday, but Mr. Starky didn't have an attorney. I didn't see when they pushed it out to.
All right.
Yeah, I can answer it. Scheduled for the 6th, and I work with the public defender because they'd appointed me, but I hadn't got the appointment, so I'll be representing them in that as well.
Okay, excellent. Thank you. And we are in victims' rights compliance, correct?
Yes.
Ms. Bauer, Victims' Rights Coordinator, are we going to have any victim impact statements today?
Yes, Your Honor.
How many?
One.
Just one? Mr. Keen, did you receive a copy of that PSI report?
Yes, Your Honor, and I'm not noting any material errors either.
Okay, and did you go over that report with Mr. Starky?
Yes, Your Honor.
Did you thoroughly go over it with him?
I had a limited time because we had a phone disconnection, but I went over the main points and the recommendations.
All right, and so you went over the bulk of the main information to ensure that he can review if there are any errors?
Yes, Your Honor.
Okay. We will begin with the victim impact statement. The victim may come forward, have a seat at the black bench. Victim may state their name if they wish, or simply the initials. Yes. And if you are going to read something, please make sure that you read it slow, you enunciate your words. The court reporter needs to take everything down accurately, okay?
My name is Jan Lodermeyer.
You can sit if you wish, or you can stand, whatever you prefer.
Last name is Lodermeier. Currently, I'm 911 dispatcher for Burnett County. First of all, I want to thank the court for giving me this opportunity. As a corrections and communications deputy for Burnett County, it was my job to keep inmates safe, secure, and hopefully healthy. When Justin Starky was unresponsive in his cell the morning of 3/29/2024, sorry.
And that's okay. Take your time. You can take as much time as you need. We have the rest of the morning scheduled for this case. So if you need to stop, you need a break, you can take that time.
My partner and I at the time went into his cell to make sure he was okay, as he was unresponsive. I bent down to touch his shoulder. He didn't really respond. He started to respond. I thought he was going to sit up. He kicked me in my stomach. I went flying back into a cement wall and I fell to the cement floor. It's the last thing I ever expected from an inmate that was playing, in my mind, possible to attack myself and possibly my partner in the cell. As a result of that action that day, my life has changed drastically. There's things I can no longer do. Correction officer is one of them. As my surgeon is concerned that it could happen again. Maybe yes, maybe no, but after 15 months, the doctors tell me I'm as healed as I'm going to be, which means constant pain, constant numbness, and sometimes tingling down my legs. As for Mr. Starky, my anger is never going to go away. I am not a vindictive person. But honestly, I hate that man for what he has done to me.
And I'm just going to say, I appreciate your emotion. This is not a time to,
I know. That's
To
all I'm gonna
attack.
say. That's all I'm gonna say about that,
Okay.
okay? I am no longer a corrections communications officer, deputy. I am now a 911 communications deputy. My life now is to help people that appreciate what 911 communications deputies do. And that is to help the community and save the community when we can.
thank you. All right, Mr. Schmidt. Argument and sentencing recommendation, please.
Sure. I'm going to be arguing for what the PSI recommends, which is 2 years initial confinement. Let me just make sure I say it accurate. 2 years initial confinement, 3 years extended supervision on the battery, and 1 year jail consecutive to it on the other count. So effectively, the 1 year jail gets converted into a prison sentence by way of Wisconsin statute. Mr. Starky has 338 days credit per the jail. This is a 35-year-old man with a traumatic brain injury that was inflicted on him when he was a baby. However, his criminal history only really began within the past 5 years. The implication there is that the criminal behavior cannot be solely attributed to the traumatic brain injury. He has been placed on probation 4 times and been revoked 4 times. He was on probation when some of the conduct at stake in these cases occurred. He is not a suitable candidate for probation. He gets disability, that's been confirmed, and at one point on information belief, I believe he was also getting civil payments from the result of how his traumatic brain injury was inflicted. I do not know if he still gets payments for that today. The core behavior of Mr. Starky in most of these cases is him assaulting and harassing correctional officers. The assaults and harassment show patterns of deliberation and planning and intention. They were not reactive or in direct response to a frustrating stimulus, such as how people might react if they have a traumatic brain injury and fly off the handle. In 24 CF 91, Justin Starky was apparently having a seizure when COs went in to address it. You heard an account from the victim in that jail already. As soon as COs were in range, Mr. Starky shot up and assaulted them, in particular, the full force kick of JL that caused life-altering injuries. This happened March 29th, 2024. The PSI demonstrates a lot of additional information that the PSI writer acquired contacting other jails that Mr. Starky was in both before this incident and after. And what the PSI writer discovered was that for over a year before this and sometimes afterwards, Mr. Starky has been in other county jails and he has been doing the same behaviors. He has been faking seizures and medical issues to trick COs to try and come in and aid him. The jails have reacted in different ways. Eau Claire seemed to have figured out this and just wouldn't go in and expose their COs. They would see the fake seizures, document it, and then document Mr. Starky's behaviors afterwards, which show he was clearly faking it. Sometimes his reactions have been violent to them not coming in and checking on him, say attacking the door or the cell. His assaultive behavior has also been directed at inmates in those jails. In 24 CF 248, COs came in to talk to Starky to stop applying cleaning solution to the mirrors in the cells that they use to see in. They first tried to do it in a safe manner through the intercom. He wouldn't listen and kept doing it. The CO went in to talk with him. The CO's posture in the surveillance camera was very neutral. He was not approaching Starky. He was just casually standing there talking. And then eventually Starky got mad, assumed a charging posture and charged at the deputy. It was completely unprovoked. He wasn't even touching Mr. Starky or approaching Mr. Starky when he was attacked. 24 CF 109, Mr. Starky urinated on the wall and floor of his toilet and used a Kool-Aid pack, like the powder solution, to put it on it so it would soak it up to make it clumpable so you could pick it up and it would be throwable, and threw it at a deputy, a correctional officer, I should say. Again, showing deliberation and planning and really an intent to humiliate, I would say. I specifically went through the facts in these jail cases because they show something you don't really see in some of his other cases, this planning deliberative element. Mr. Starky is intentionally using, not just in these cases, but in the descriptions of these other jails, he's using the empathy of his COs, their desire to help him and to make sure he's not having medical issues to gain access and harm them. He's using positive traits and positive things they're doing against them. It's not just immoral in that sense. It creates a broader public risk to all of the other inmates that COs have to be thinking about and be cautious of other inmates who might be faking just to gain access to harm them. It also shows this more malicious element, because this wasn't a one-off in the JL case of the faking the seizure. We see from the Eau Claire logs, this has been something he's been doing an extremely long period of time. It's a repeated plan that he keeps trying to do and presumably will keep doing in the future. I say that I presume he's going to keep doing it in the future because of how Mr. Starky talked to the PSI writer about the correctional officer cases versus the case with his mother. The Eau Claire conviction mentioned in there is the one where he assaulted his mother in his home. So that's different than the CO ones. That was a public assault, more akin to the first Burnett County case, the DC in public. And those two cases are more of the getting frustrated and attacking somebody cases. The way he talks about the case with his mother, it's because it's his mother, he says he's sorry. He says something to the PSI writer that when he's asked about whether he feels bad or sorry about what happened, he says just about his mother. He, even at the point when he was talking to the PSI writer, wasn't empathizing with any of these COs, not just the victims in our case, but really the Eau Claire ones, the other county jails where he's done this, the county jail where the CO is coming in with the medical cart, with the medicine that he needed, and he attacked them when they did it. So what am I highlighting? So I've already indicated we have to start first with considering probation. The statute requires that it should be rejected out of hand because of the failures on probation, because two of his recent convictions involved assaults in public in the community, the DC in Burnett, the Eau Claire incident with his mother. The fact he's a danger in the jail to correctional officers itself is also indicative. He can't be treated in the community. That's indicative he needs a higher level of confinement. And that would be the Wisconsin state prison system. They have much better resources. They can have a better documented file and establish easier to use protocols than the county jails he's bouncing to and forth from Polk to Burnett to Eau Claire, and better establish a protocol where Mr. Starky cannot harm officers, correctional officers. So that brings us to McCleary. Gravity offense, protection of the public, rehabilitative needs of the offender. The gravity of the offense is severe because of the maliciousness of what's happening here, and because of the pattern that can be traced back into 2023 and also forward a bit as well, of really just wanting to attack these jailers. If you look at what is the intent, what is the impetus of why he's doing this, it's not, these are not contacts where the COs are initiating contact with him. He's initiating contact with them by faking medical issues or deliberately doing something he's told not to do. He's seeking provocation. He's seeking physical contact. And as a result, he's harming COs. He's humiliating them. he's caused an injury to one CO that has prevented her from being a CO. That Mr. Starky has robbed from the county somebody who's extremely talented and experienced in that role forever. We can still keep her in another role, but losing her as a correctional officer is a huge blow to our county. We're constantly trying to recruit new correctional officers because that's a hard position to get people and find people who can do it. And Mr. Starky exacerbates a real public problem. And that's indicative of a higher gravity offense and also the nature of the injury. We need to be able to protect our correctional officers. And I think that through the gravity of the offense, through McCleary is the way we address that. Because there are not special rules for the police or for correctional officers where people can swear at them or be mean to them or throw urine at them or assault them, and they can't for the public. The COs and the deputies are also the public because they're also people, and they deserve the same respect. And they deserve the same respect for their personhood and their bodily autonomy as anybody else. Protection of the public is odd here because, like I said, most people don't think of correctional officers or police officers as the public, but they are in the sense of how that term is used. When you have an individual who's incarcerated, the public that we're seeking to protect in this case is the correctional officers. But there is also the broader public who's at danger with Mr. Starky. One of the reasons, the case that caused him to come into our jail to begin with, was him being public and threatening a woman who, again, was just trying to help him. With the failures on probation, with him assaulting people in public, trying to help him, with him assaulting correctional officers who really just, their main goal is to have a neutral, safe environment for all the inmates and themselves to keep everybody happy. They're not going in there and picking fights. And his disruption of peace, both in the community and the jail, indicates a strong need to protect the public that I think prison is necessary. That brings me to rehabilitative needs of this offender. Mr. Starky, I think we see a pattern over the past 5 years where he's growing increasingly antisocial and malicious in both his behavior and his thought processes. This can't be traced to his TBI from 1991 because he doesn't have this criminal history going back to 1991. It happened in the past 5 years. They're a result of him and his choices and his behavior. We really see in the PSI, in his statements, a profound lack of empathy for people he doesn't already have a personal stake in. That's why he feels bad about his mother, but nobody else, not the woman helping him at the hotel, none of the correctional officers he's ever assaulted or thrown urine at, of which there's no justifiable reason. They demonstrate an increasingly selfish view that Mr. Starky has, where if someone makes him angry or he feels he's not being respected, he says to the PSI writer, he's justified in what he does. That's highly concerning because it shows a lack of respect for others, a lack of respect for bodily autonomy, which is really one of the cornerstones of modern society. If his empathy is non-existent to this extent, if he's this selfish in his worldview, if his locus of control is so internalized, what that means is we have to rely on punishment to deter his behavior. There's no other choice because the decision to change isn't going to come organically from Mr. Starky. He's been continually assaultive for years now in these jails. So it has to come from fear of punishment. It has to come from deterrence. If we don't address punishment through the criminal justice system in that manner, my big concern with the implications of how Mr. Starky talks about his TBI and his ADHD is he's going to come to the conclusion that so long as he ties things back to that or medical issues and he doesn't get punished, then it's going to reinforce the behavior. if he's able to use those diagnoses as an out to avoid punishment, then he's being told, you can still do that because of your condition. And I take specific umbrage at that in particular, because there's a lot of people out there with TBIs, with ADHD, and other conditions. These don't apply to Starky in particular, like schizophrenia or bipolar, conditions that can cause a person to behave erratically or become violent or aggressive. And a lot of these people, most of these people, don't get assaultive. They don't have criminal histories. They aren't attacking people in jails. They're not even in jails because they're still capable of having free will. They can still make the choice to, hey, I want to better myself. I want to get along in society. I want to treat my condition. I want to be responsible. They're not playing up their injuries. They're not playing up their illnesses. They're being responsible members of society. And there's no reason Mr. Starky can't either. Prior to 5 years ago, that's what he was. I asked the court not to reinforce that behavior. I asked the court to do a prison sentence to deter it. I think based off of the sheer volume of people hurt, the consistent pattern of behavior before and after these assaults, the nature of one of the read-ins being in the community, and the past conviction in Eau Claire not that long ago, also being with his mother in the community, I don't see how it's possible to supervise and treat Mr. Starky safely in the community. We've seen through the facts of the case themselves, he can't be safely treated or rehabilitated or deterred in the jails. So the next step has to be prison. I'd ask the court to follow the PSI recommendation. Thank you.
Thank you. Mr. Schmidt, before I move on to the defense, one of your focuses was rehabilitation. Punishment was an aspect as well, but rehabilitation, where the court should look at that. And the fact that in this last 5-year history, that your argument stated that Mr. Starky, excuse me if I'm not saying it as eloquently as you did, but Mr. Starky was not availing himself to the rehabilitative services. What would you recommend as in at least conditions for rehabilitative needs?
That's the rub of it, because like I said, I don't think the 5-year behavior can be attributed to the traumatic brain injury. There has to be something else going on, which means I think he needs a mental health professional to assess him and work something out and potentially even get some sort of medical paradigm going, if a sedative. That's why I think the Wisconsin State prison system is better, because they have a better medical system.
All right. Mr. Keen.
Well, Your Honor, first, acknowledge Dispatcher Lodermeyer's statement. It's powerful and sad, and no matter what you decide today, unfortunately, we can't go back to that time. Mr. Starky can't go back to it and undo it. And I'm sure that, I presume the deputy dispatcher appreciates the support by many members of the local law enforcement, because in a department the size of Burnett County, that's a fair share of the number of officers who could be on the street. So now moving to a little to the fact of the matter here, but I wanted to acknowledge that first. Not going to deny that it's a serious offense. Dispatcher Lodermeyer has had a change in her career. I read her statement talking about losing her ability to golf. And to say that isn't a severe and a lifetime consequence would be, trying to make a mockery of things today. And I am not going to do that. And I certainly don't agree with the idea that, yes, law enforcement is by nature a dangerous job, because you are called, law enforcement officers are called to deal with people when things are at their worst. And in a correctional setting, the correctional deputies are there for people who have either been convicted or being charged with criminal acts in the community that often involve violence and or substance abuse and mental health issues. That said, I would never try and say that's like a mitigating factor because, well, that's part of their job, because, you know, if we believe that, then trying to find anyone to be a correctional officer if they don't feel support is going to be harder than it already is. But the question you have, and the one I thought of, and the one the DA has thought of, is what should happen to Mr. Starky from here on out? And if you look at his record from 2021, you know, February 2021, so we're looking at a little over a 4-year period. We're looking at a time in Mr. Starky's life where he's been, you know, kicked out of his home, homeless for part of it, wandering around, you know, in jail most of that time. The last time he was out of jail, I represented him on the probation revocation hearing where he got out. You know, he was put in a hotel for a couple days. And unfortunately for him, you know, trying to get assistance and getting back to housing, because he'd been in custody so long, it was hard to do. And he wasn't able to avail himself of Burnett County's ADRC service because prior to incarceration, his last residence was another county and he'd have to apply there. So I'm not going to argue for straight probation either, because I don't think that the court would treat that seriously. My issue is that, because I've seen this here, you know, with the DA's recommendation and in Sawyer County, one of the issues we have is we have mental health care issues. I'm not talking just about TBI, because the DA's point out that for just TBI, you'd have a longer history or it wouldn't happen at all. But there's certainly some mental health issues that Mr. Starky's been facing, and something obviously has increased them. But over the past several years, I mean, he had several competency reports because 3 different attorneys, 3 different counties thought something was up. And the competency barrier is fairly low. You know, it's just whether he understands the charges. And then, you know, if you're looking at, you know, mental defect or illness, you know, the standard for that is a fairly tough road to meet. He's in between, I would say. Not in between those, but in between a regular functioning person and someone whose mental illnesses are such that a mental defect defense would be in order. If you look at what's happened over the past 4 years, the vast majority of time he's been in jail. When he's been out, he hasn't really had much for services or time. And, you know, his relationship with his mother was, you know, damaged obviously for the Eau Claire case, and she chose not to participate in this hearing. So the state's effort here is to suggest that prison is the place where you can get services. And I think we're sort of doing correction officers, along with Mr. Starky, a disservice, because we're trying to move along mental health services. You're using prison as a place to provide services that are probably more appropriate in other locations. Because if he didn't have some of these charges, I mean, you know, there'd probably be civil commitments and other items that would also be appropriate. Because there you have, you know, behavioral control issues. And then although he did not express remorse it appeared to express remorse in the PSI, he has expressed it other times when talking to officers. He's expressed that in court. he's expressed that in other situations. So I don't think characterizing him as a remorseless man is there. But, you know, Mr. Starkey's a man whose mood changes because it's talking about being cooperative some days, not so cooperative other days. You know, your impression of him probably depends on whether you see him on a good day or a bad day. So I think when you look at the rehabilitative needs, I don't think that a prison sentence is necessarily going to accomplish that because Mr. Starkey has been in jail for most of the past 4 years, bouncing back and forth. And then when he's out on the streets, he's, you know, hasn't had a lot of the services. The PSI said that he hadn't had really much for mental health care in the past 4 years. So the question is how to deal with it. And I think one way to deal with it would be to, in 24 CF 109, I would suggest a sentence of time served, which according to the DA was 338 days, be appropriate instead of the 1 year in jail. And that in 24 CF 91, I would suggest a consecutive sentence with probation and a period of confinement as a condition of probation of 60 to 90 days from today for a specific purpose. So probation can identify places for Mr. Starkey to receive, you know, get some evaluations, mental health evaluations, whether he needs a inpatient stay at a mental health facility or some other resource to allow time for that to happen. And because again, the thing that's startling to me is when I look at it, I mean, other than the harm to Deputy Lodermeyer, which I'm not going to at any point minimize, because that, I mean, that's the worst consequence of the case, because, you know, regardless of what you decide, Mr. Starkey will presumably get out of jail or prison. But unfortunately for Deputy Lodermeyer, that's, you know, lifetime consequences. But in terms of Mr. Starkey, you know, like the last time he got out, he was on a street hotel for a few days. There's times he's bounced out. He has, you know, 2023, you know, he's kicked out of his residence. He's a man who, before he started getting in jail, had been getting services through Inclusa, and he'd had a representative payee and other things. And I think if we pursue prison at this stage, we're just setting them up, okay, go to prison. And then when you come back out, you're the same person. Mr. Starkey's, you know, through the conduct, through the, you know, there were four competency reports sought, and, you know, 3 different attorneys had some of the same questions. Mr. Starkey's talked about someone taking his word fines and a lot of other things that indicate some potential, and someone frauding his name and committing crimes. So there are mental health issues that frankly, I don't believe have been diagnosed because Mr. Starkey has been in county jails for most of the past 4 years. And I think when you're dealing with rehabilitative needs, the way to get rehabilitative needs for someone with mental health issues is to get them diagnosed, because we don't know what medications may be appropriate, because Mr. Starkey's access to mental health in the past 4 years has been spotty at best and limited to what is offered in county jails. And another thing with the conditional jail is that during that time, the county, if they believe that that if probation is not able to, you know, work on getting Mr. Starkey some inpatient treatment or intensive outpatient, whatever mental health provider recommends, because that's certainly not my role, you know, then that would allow the county to file for a potential civil commitment so that Mr. Starkey could get mental help one way or another. You know, because somebody shows potential danger to the community, versus just going straight to the, well, we're going to use prison to warehouse them for a period of time and then hope that when he gets out, he's close, he may be close to the same boat. Mr. Starkey does have some tools. He's qualified because he did qualify for SSI. He had a representative payee. He does need some time to get those services set back up because since he's been in custody for so long, you have to start from scratch on applications. And I think the better way to focus on the rehabilitative needs and the protection of the community is to get Mr. Stark focus on a program that gets Mr. Starkey mental health in the shorter order than, go to prison, go to classification, because they recommend 2 years. So, I mean, you're looking at almost half a year before civil services. And we know that the prisons aren't a panacea either, because the prisons talk about shortages in services, staffing for mental health, staffing for their own safety. So in essence, we're the DA's recommendation transfers the burden to the prison system, which, useful for Burnett County, but doesn't really do anything more in terms of rehabilitative needs than the proposal we would suggest is, to recommend that time served in 24 CF 109, which is the 338 days, 24 CF 91, consecutive, 3 years of probation with, I'd say 60 and 90 days of conditional jail to allow for probation to try and figure out, if there are services they can get them into through Department of Corrections, whether it's a halfway house or some other supervised environment. And if the needs are more severe, then the county could, through Corporation Council, consider, a mental health evaluation or hold versus just hoping that we make the problem go away by prison. Now, regarding protection of the community, and I will include the jail staff and I'll include the correctional officers in the Wisconsin State Prison System, focusing on the mental health treatment to deal with whatever Mr. Starkey's issues may be that go beyond TBI would probably do more to protect the community than just, go to prison for a few years and hope that they can provide you resources you haven't been provided in the past 4 years. Because Mr. Starkey is, like I said, he hasn't had them for the past 4 years, a supervised placement with mental health services would probably do more to protect the community than just make him the problem of the Wisconsin State prison system. So with that in mind, like I said, I'm not suggesting a pure probation. Suggest that the 24 CF 109, I think our argument would be treat that as, use that for the time he spent in jail. And then in 24 CF 91, I'd say 60 and 90 days of conditional jail, and that's consecutive. So to the 24 CF 109 with 3 years probation to allow time to coordinate some mental health services and between probation and potentially the county, decide if that, how Mr. Starkey can get some of those services that he needs rather than just trying to turn the jail and prison system into the mental health providers. Thank you.
Thank you. Mr. Starkey, I'm now going to go to you and ask if there's anything that you would like to share with the court. And you can fill the court in with anything that you think that was missing with either attorney's arguments or anything that you think was missing from this PSI packet, anything that you think that you may have forgotten or didn't recall to tell that PSI author, or anything with regards to any remorse or any other thing with any of these cases. But you don't have to provide a statement today, but you do have that opportunity. Is there anything that you would like to say? And you can take as much time as you need or would like.
Could I
can talk
talk
to your
to
attorney
him
too. Yeah.
first?
Sure.
You sure can.
Yes. So like, if you're talking about some of your mental health issues you've been having. Because I really. Not the thing to focus on. I focus on what's going on in your life. It's constant. Be quiet since one. There are times you remember expressing remorse to just that versus just, okay. Okay.
All right, Mr. Starkey.
With the officer that I kicked, I'm very sorry that I did that. I didn't mean to do it. Right after I did that, when I got put in one of those single pods, I actually cried really hard. And I feel really horrible for that. When I cried really hard, I was looking up and I poured my whole bottle of soap all over myself. Still with my clothes on. Because I did that to a woman officer. I did not mean to do that, so I'm sorry if she is still here. And with any of my mom's cases, I've already said sorry to her. So that's pretty much it.
Right. Thank you, Mr. Starkey. And Mr. Starkey, if I am going over anything when I say anything here in my decision and you don't quite understand it and you need to talk to your attorney, you can just let him know, tap him on the shoulder, and we will stop so that I can make sure that you fully understand everything, okay?
Okay.
Now, we're here today for the sentencing portion of this case. And in preparing for this, you had to speak with a Department of Corrections officer to prepare that report, the PSI report right here. And so you provided a whole lot of information to the author of this report, as well as giving a whole lot of information to your attorney so he can better understand you and the cases and where you were and where you are here today. Now, in sentencing an individual, a person in front of the court has to look at certain factors. I have to look at first the nature and the gravity of the offense. How serious is this case and the other matters related that may have been dismissed and read in, those other cases that you may not have been convicted of any charges, but they are a part of this matter. The court also has to look at the defendant, your character, your past criminal record, and your needs for rehabilitation, if there are any services that could better help you or help you fit into the community and not be a danger or a risk. The court also has to look at needing to protect the public. And here the court looks at protecting the public as a whole, the entire public, and in particular, other groups of the public that may have been impacted by your behavior, by your conduct here. And in this particular case, it would be not only this case, but the other corresponding cases and other cases that you've been convicted of that the court reviews would be those jail-related cases with the correctional officers or other law enforcement officers. The court also has to look at the effect of the victims involved in the cases and hear their statements and how it impacted them. The court also has to look at any what's called undesirable behavior patterns. If there is a pattern which can come out of the cases and out of the facts, and if it's undesirable, if it shows any negative traits or negative characteristics. I also have to look at culpability, meaning your ability or your making these decisions and your guilt, if there was any intent, deliberation, planning, maliciousness, those types of things. I look at your education and your history, which would include that TBI, that traumatic brain injury, and any other mental health conditions that may have already been diagnosed, as well as the other medical conditions such as your ADHD. I have to look at deterrence, and deterrence means to try and stop others from doing something. And that would be the general deterrence, stop other people from committing similar crimes or crimes of this nature, and specific deterrence, meaning to deter you, to try and stop you from committing these types of crimes in the future. And the court also needs to first look at probation. And Mr. Schmidt, the district attorney, went over that in his argument, that I am directed by my higher courts to first look at probation unless confinement is necessary to protect the public from further criminal activity from you, the defendant, unless you need correctional treatment because any types of treatments or other services outside of the correctional institution has not yet been successful or been sought after, or if probation would unduly depreciate the seriousness of the offense, of the crimes here. When I'm looking at this case, I look at the matter of all of the charges in all of these cases together. And you had multiple cases. I believe there were 4 cases that were in front of this court that you were engaging in litigation. All right. And in looking at these cases and in adding the maximum possible penalty, if you were to go to trial on each of those cases, and if you were convicted on each of those charges in those cases, the maximum possible penalty that you would face would be, it would be a total of 20 years and 9 months of initial confinement. That means initially serving within the confines of a prison and or jail cell, and 20 years of what's called extended supervision. That would be similar to what people think of as probation or parole or something like that. In Wisconsin, we call that extended supervision after release from prison. So 20 years and 9 months of initial confinement with 20 years of extended supervision. That's a lot of time. So a total of over 40 years of a prison sentence with some jail mixed in, because there were, I believe, 3 A misdemeanors and 1 B misdemeanor. The rest were felonies. Through negotiation and discussion and plea talks with your attorney in the state, and in reaching this global agreement, that agreement lowered the amount of potential incarceration and extended supervision. And in the case, the maximum possible penalty that you would face with this agreement would be 4.5 years of initial confinement with 5 years of extended supervision. So there was an extended substantial benefit for you in reaching this global plea agreement. And so you did receive a really good deal in reaching this agreement. The primary dispute here today is I need to determine if this is a prison case today, because I have the state arguing for immediate prison, and I have the Department of Corrections making a recommendation for prison, and I believe the state and the Department of Corrections are on the same path, the same avenue with regards to their recommendations, or whether or not this is a case, as your attorney argued, for probation with some conditional jail. And so in looking at those two things, because they're so vastly different, the court will need to look at those rehabilitative needs. And quite honestly, the most serious here, this is a serious offense, everybody acknowledges that, but the protection of the public. And what can the court do to try and ensure the protection of the public? I can't guarantee protection of the public, but I can try and ensure to the best of the sentence's ability for public protection. So that is where the court is looking at here. Now, I did review very thoroughly your pre-sentence investigation report. And as argued by the district attorney, your criminal career, your criminal charges and convictions are not very lengthy with regards to your history, just in the past 5 years or so. You are 34 years old, so that would mean they started around when you were 29 years old. And what happened at that time, the court is unsure, and I'm not even sure if your attorney is aware, or even if you are aware of what may have happened or why you have may have went down this other path. Because from the time you suffered the TBI, and that is indicated from 1991, when you were approximately 6 months old, you had that head injury. And from the time that you were a baby until the time you were 29, although you were suffering from some disabilities and suffering from some mental incapacities, you were still able to perform and to be conforming to the public and what a law-abiding citizen should be. You were not engaging in any criminal activities. But then approximately 5 years ago is when it started, and it seems to have derailed because we have multiple cases with multiple convictions with multiple victims. And if you look at the cases, I don't believe you're necessarily selective at your victims. I believe it's victims of opportunity. And it would not matter, because it looks like you have individuals that you know, individuals that you don't know, people that you may be close with, like your mother, or people who may have authority over you or have the ability to enforce authority to you. If you look at the facts of the cases in front of the court today, and if the court does review your criminal history and those convictions, the court feels that the state is making a very strong argument. The facts play out as the state has argued, that in your conduct and your behavior that harms and hurts individuals, it has been deliberate, it has been planned, there is intent to do harm or intent to be in a position where you could cause harm. And it is apparent with some of these victims being individuals who, as the state has said, has shown empathy to you, has tried to ensure that you are not in harm's way, that you are not injured, that you are not at risk. And when they come and assist you, You hurt them. And it's essentially as a lying in wait, as a tiger waiting and watching its prey and then attacks. And it causes serious injury to individuals. I believe in the Eau Claire case, I think that it was alleged that you had maybe broken your mother's wrist. In this matter, you have kicked the correctional officer so hard with such force that she was thrown across the room and hit the concrete wall and suffered extensive injuries, where she is now in a form of disability herself and cannot return to a job she loved. And now she is in another position she likes and is doing and is helping people, but that is not the career that she had wished to be a part of. And so you're not only taking away people's health and people's physical health, people's mental health, but you're taking away livelihood as well. Their ability to not only provide for themselves financially, but to feel fulfillment in what they may have been doing as a career. And that's where it becomes a little bit more aggravated when you see the gravity of the offenses, the gravity of the actions, the severity of the actions, and the fact that they are so malicious and deliberate and have so much intent. And there is a pattern that this is what you do. Again, a tiger lying in wait for its prey. So there is that undesirable behavior pattern. And it puts the public at a severe risk. And the issue here is not only the public as a whole, the public in general, because lay people, other people who are not connected to this judicial justice world, are at a higher disadvantage than the officers or the correctional officers that you engage with, because they're not aware of how dangerous you could be or the threat of harm that you cause. But when we're looking at having you in a confined setting, and we're looking at the public as the correctional officers or law enforcement officers, they're aware or potentially aware of the fact that you are a danger, you are a risk, but they can't be removed. They're in that position. That's their job. Their job is to ensure that everyone incarcerated is well taken care of and that they are not a danger to the other jail community. Because it seems like in these cases from 5 years ago until present, they continue to escalate. They continue to escalate in harm, in actions, and in damage caused. And with each passing year, with each passing case, without having the punishment to deter, you become more of a ticking time bomb where you're waiting to just go off and explode on a poor individual who may or may not be aware of the risk. And then you cause serious, sometimes irreparable damage. And I've heard your statement, and I hear that you have remorse for the injury of the correctional officer. And I'm glad to hear that today. In reading the PSI report and your statements to the author, those statements from you were more so like you feel you are the victim. You feel you are the one who is being damaged and controlled because you're in custody. You don't believe you're being treated fairly. You don't believe you're being treated the same as other individuals. And I'm going to say, if you're not being treated as the same as other individuals, it's because of your aggressiveness, your violence, your danger, that the officers need to be in a higher alert. They need to protect more. They need to ensure that you have more restrictions and control so you don't explode and cause damage. In cases where a court sentences, I have to look at the least amount of incarceration to accomplish the goals of the sentence and to ensure that there will be compliance. And so I have to look at the minimum amount of jail time or incarceration to protect the public while looking at the gravity of the offense and the rehabilitative needs. The court also, in some cases, looks at punishment, and punishment is a factor, especially when we have this progressive history of increased aggravated actions and conduct towards helpless, sometimes helpless individuals or clueless individuals, and even towards, as I stated, the correctional officers who may be aware of or should be aware of the extent of your violence. The court can't get around the fact that you are an extreme safety risk, and the number one goal here is to protect the public. I need to protect the public, and I need to do so in the minimum amount of time, which would be consistent with those factors and the needs of the defendant. I do recognize and understand that there are rehabilitative needs and that there could be other mental illnesses or disorders, as your attorney is arguing and stating, and the fact that there should be a mental health evaluation because there could be a need or a potential need for medical treatment. So the court addresses the rehabilitative prospects and will do that with the conditions of either probation or extended supervision to ensure that that can be addressed. The court wasn't aware to the full extent, at least until the argument of the state, that it's not just the jail in Burnett County, it was the jail in the other counties where you are housed, that they knew or were aware of the potential violent propensities, that you could be a weapon, a dangerous weapon. And so if the court were to place you on probation and have individuals who are not protected with tasers, that are not protected with weapons, that are not protected with other things, it would unduly depreciate the seriousness of these offenses and the seriousness to watch and to provide you services. It would be sending out a lion in a chicken coop. So based upon the seriousness of the offenses and the fact that they continue to get more aggravated and they continue to cause more and more harm to the victims, incarceration in prison is the only sentence that the court finds to be appropriate. Because again, it would not only unduly depreciate the seriousness of all of the offenses, the court would not be in a position to protect the public if you were not confined. And the fact that correctional institutions can provide you with treatment and or services before you are released. Your attorney made a statement that everybody would be, if you're sent to prison, that everybody would be just hoping the problem would go away. No one's hoping that. No one believes that that is even a possibility. That is not the purpose of prison. The purpose of prison is punishment, and the purpose of prison is to ensure that the public is protected for that ability, or protected for that amount of time to a high ability for the time that the defendant is incarcerated. That's the goal of prison. Rehabilitation is a goal of prison, but it's not hoping the problems go away or hoping that the defendant gets quote unquote fixed or cured. That doesn't happen. A person can change, a person can make changes in their lives, and they can do so while in prison, but that has to be a conscious choice. The person has to be making the steps while in prison to do that, and doing the classes in prison to make sure that that can occur. With each of the charges, the court is only going to assess $250, the DNA surcharge. You have $500 posted, and that will go towards the surcharges. I'm waiving the rest of the court costs and fees. Your ability to pay is very little. You're on SSDI, but you would need to reapply once you are out of custody and out of incarceration. So I'm waiving the rest of the court costs and fees and only doing the mandatory DNA surcharges. With regards to 24 CF91, which is battery or threat to a law enforcement officer, a class H felony. The court believes that that is a very serious offense, and it caused serious injury and an impact on the victim. And the court needs to not only deter you specifically from engaging in this type of conduct and behavior while incarcerated at any point in your life, if ever again, and also has to generally deter the public from this behavior, because correctional officers are doing their job. They should not have to worry whether or not they're going to be maimed, whether or not they're going to be disabled, whether or not they're going to break a bone, or whether or not they may not come home at night on their jobs. And people who are incarcerated need to understand that they must follow the rules, and they must not engage in this type of conduct or behavior, or there will be punishment. With regards to that count in that case, the court is going to sentence you to 3 years of initial incarceration and 3 years of extended supervision. With regards to 24 CF109, which is throwing or expelling bodily fluid or substances, a class I felony, the court is going to sentence you to 1.5 years of initial confinement and 2 years of extended supervision. They will be consecutive to each other and consecutive to all other cases in all other counties or jurisdictions. The escalation in conduct and behavior, the escalation in the damage and injuries to the victims makes this case extremely serious, not only to you, the defendant in these cases, but to the public as a whole, to ensure that there is at least deterrence factors. Conditions on extended supervision, absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, a mental health evaluation, which would include the MMPI-3 test and or any other similar evaluative test as your agent would deem appropriate and to your comprehensive level. The court will order that you have a psychiatric evaluation and exam, and if prescribed medications, you take them as prescribed. You follow all recommendations of both of those evaluations. I said absolute sobriety. No contact with Burnett County Government Center unless it has court-related matters or you have other county business. No contact with the victims or their residences or their employment. Your no contact will be able to be reviewed at any probation review hearing upon request of yourself through your agent. You are a resident of Polk County. You've always been a resident of Polk County, or for the most part, and not a resident of Burnett County. So this should not impede your ability to travel. You were to have no contact with Burnett County except traveling through. If you need to get to other medical appointments, your probation appointments, those types of things, unless there is approval from the court. And again, that can be received through a request and a probation or extended supervision review hearing. You have 338 days of jail credit that the court will provide to you to use towards your sentence. As to your mother, I don't have to provide that no contact. That is something for the Eau Claire matter and her desire to have contact with you. The court is also going to order that you engage in some type of mental health or therapeutic class or course as it relates to self-control and self-regulation. The court believes that this sentence is not only necessary, but it's imperative to assure the public is protected because you continue to be risky and violent and engage in escalating criminal behavior and contact with victims. And the court is concerned that the next contact you would have could cause more serious damage than disability. It could cause death. The court is ordering your DNA. You must provide that to the jail. You are not eligible for the challenge incarceration program. You are not eligible for the substance abuse program. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe that covers everything, Mr. Schmidt.
There's one thing we need to cover yet. At the plea hearing, the defendant stipulated to restitution. The restitution was $1,500 to the victim JL and what workers' compensation had paid for a certain period of time, which totaled $8,866.91. In between the plea hearing and the sentencing hearing, the workers' comp paid out more money or approved more claims to be paid. So the insurance company updated the restitution claim and submitted that. So the new total is $24,956.09. I would inquire with the defendant if he stipulates that new claim or if there needs to be a restitution hearing for the difference between.
Mr. Keen,
I think a restitution here would probably be in order.
well, I'm going to order, how much was directly owed to victim in this case? 1,500?
1,500 is directly to victim. At the plea hearing, they already stipulated to 8,866.91.
Well, I'm only gonna order what's stipulated to the $8,861.91. He has no ability to pay now while he's incarcerated, plus when he's released, even if he were to apply for SSDI, he would only receive about $900 a month in what I'm getting from the packet. And it's workers' comp, it's not the direct victim. So the court is gonna grant the stipulated amount in $8,866.91.
With that in mind.
Because I believe that would be your argument, inability to pay.
Yeah. Yes, you are.
Anything further
No.
from you, Mr. Keen?
No, you are.
All right, then we are adjourned.